All right. Good day, everybody. This was supposed to be a Facebook Live, so it will be a little bit more interactive. There were some technical difficulties, so we switched over to Zoom, and you guys are now seeing it on Facebook. The information is still great, nonetheless, live and interactive or recorded. It's still great and it's still relevant. I wanted to speak about what everything that's going on with COVID-19 and other life situations, the topic of estate planning. The issue is I know this much of estate planning, right? And I've always learned to kind of stay in my lane. So what I've decided to do is what we decided to do was kind of come together so we can present effectively and efficiently on the topic. And the only way to do that is get someone that's well respected in her field of estate planning. And that is none other than Natisha Matthews. Did I get that correct?
Yes, sir.
That's good. That's good. Miss Matthews, please talk to us. Tell us a little bit about yourself, your background, and we'll jump in.
Absolutely. Thank you so much, Pastor, for allowing this opportunity to share about estate planning. As you mentioned, I am an estate planning attorney, so I do trust as well as trust in estates. It's my passion to give people the knowledge and understanding about what is estate planning, because for many of us, we don't understand it. And I think that's why when things like COVID-19 happens, we are tend to be not prepared. We prepare for baby showers, we prepare for bridal showers and pastoral anniversaries, but because we don't understand what estate planning is, we tend not to be prepared for what we're going to do with our estates and leaving our loved ones to kind of handle things that tend to be chaotic. So in addition to grieving our loss, now there's on top of now we have to deal with figuring things out in addition to grieving. So I am an estate attorney, and for years, and it's my passion to do that. And especially now more than ever before, as you know, I do workshops on this topic, and now it's more than ever before is to bring more awareness to what estate planning is, so that in the event moving forward, that we can be better equipped, more knowledgeable, and have our estate planning documents in place. I think it's important. I think one thing is to dispel the myth that again, to define, we don't have understanding, we don't have things in place because we don't know what it is and we are unable to define it. So let's talk about what is estate planning, define it before we even go moving forward. So to define estate planning is pretty much being able to first have all of your assets listed, and being able to properly delegate it where you want it to go when you pass. I think that's the most simple way to articulate it, because there's some nuances, some difficulty, but in a simple form, that's pretty much what it is. And it's better that you articulate it while you're living, because once you pass, now you're leaving it up to the courts to now decide where your assets, or even where your children, if you have small children, who's going to be their guardian. So that's it in a nutshell.
So let me ask this question. Let me just start it off by asking this question. Right now, no matter what age I am or what age a person is, what is it that I should be preparing for? You mentioned estate planning is kind of listing everything and kind of allocating where you like it to go. What are some things that right now we all can do, we that are still here can do?
I think right now what you can do, because even signing wills or executing them can be a little challenging because everyone's at home, so things have to be done virtually. So what you can do now is to even list out your assets. Like, what do you have? Down from bank accounts down to insurance plans, IRAs, anything that you have, even down to furniture, clothes, whatever you property, real property, land that you have, things that you want to list, and who do you want to leave it to? We can start from there. The basic stuff, you can still contact an attorney and they can kind of walk you through best plans for what works for you and your circumstances or your situation. But it's ideal for you to list out what do you have, right? So that can kind of handle the will aspect. And then also too, we'll get into the different documents a little bit later or in this conversation about the power of attorney. You want to begin to think about, if something were to happen to you, who do you want now to kind of step in on your behalf? Whether it's in regards to financial matters, or if you want someone who will make help you with making healthcare decisions, that will be used the healthcare proxy. So you want to start beginning to think of all of those. You want to begin to think about, if I select a person A and for some reason they are unable to fulfill their responsibilities, do I have an alternate or person B? So those are some things that you can start to think about now and have them written down. You begin to think about it so that when this the restrictions, the quarantine is lifted, you can proceed with that. But even in the meantime, you can still have a conversation with an attorney about what things look like in order to draft the documents. And then again, when things are lifted, you can now fully execute them.
Now, I have a question. It's a little off. It's on topic, but it's a little different, because
Sure.
you said you need to speak to an attorney, right? So
Yes.
Just for the sake of the viewers, what kind of attorney do I need to speak to in regards to estate planning? It might sound simple, but we need to make sure that everybody knows.
No, you're absolutely correct. I think you want to speak to someone who does estate planning. So you want to get an attorney that practices trust and estates, because it's not just, oh, let me just put a will together, or I could just download something on like LegalZoom, or just get a simple will and just do it on my own. Why? Because there's things that have generic languages, or a person may just say, let me just pull something from the website or the internet and just insert your name into it. But what may be on the page may not be best for your situation. And so you want to get someone, a trust and estates attorney. That's what we kind of deem it as. That's what it's known as. Or you could say estate planning attorney that can actually walk you through, hear your story. What do you want to do with your assets? And then kind of assist you and navigate you on the best ways in order to delegate or really carry out your last will and testament, or carry out your instructions. So you want someone who actually understands how this is actually gets played out, or how, again, best practices, how I can take the information that you have given to me and to make sure that it works in a legal functioning document, the best practices, versus, again, just getting something off the internet and, I think I know what I'm doing, and I could just put, just, again, inserting names, because actually anyone can do that. But, you want to get someone who specializes in this area, because again, if I get someone who's not specialized, or I just go off the internet and just download just a generic will, it may not be catered to what I want to do. There may be something in the generic will that, someone who is not knowledgeable may not know that, okay, there's a certain provision that needs to be added, or there's a provision that will now help you to really satisfy the goal, reach the goal that you want in regards to delegating your assets. So again, if you want to do anything with your estate planning, I would it's the trust and estates attorney.
A trust and estates attorney. A trust
Correct.
and estates attorney. I just want to repeat it a few times for the people listening.
Trust and estates attorney.
You need
trust
one of
and
those.
Estates. Correct.
If your cousin is a real estate attorney and he or she does not practice or know trust and estates, you can go to them for some things, but you want to go to a trust and estates attorney, correct?
Correct. That's preferable. That's what you should do.
Preferable. Okay.
Correct.
That leads me to my next thing. Unfortunately, I spoke with one of my clients yesterday, and the client lost their spouse. And the client asked what did I suggest as their accountant, what their next step should be. And I said, well, your next step is, it was great that you called me, right? It's great as your accountant. It's great that you called me, but you need to call an estate's attorney, because there's some things that the attorney could walk you through that, as I said at the top of this conversation, I know enough to be cognizant about an estate's conversation, a vanilla estate's conversation, right? It's kind of
Right.
like going to a foreign country and you're saying, hey, I speak the dialect of that country, because you learned 3 or 4 words before you got there. And then when you try to hold an intelligent conversation with someone from that country and they begin to talk fluently in that language, and you're like, what's going on? That would be me, the
Right.
accountant, in an estate's conversation, right? And I'm good with admitting that. So here's where that leads me to. Someone loses their loved one. We don't know, right, if there is a will. We're not sure. Sometimes the spouse, I mean, I've seen situations where one spouse passes away, the spouse that's left with us has no idea about bills, because the spouse that deceased took care of everything. Um, the spouse remaining doesn't even know if there's a will, doesn't know if there's insurance policies in place. I mean, I'm sure you've seen the situations. I've seen situations where, unfortunately, the corpse of the deceased is left in limbo because there is an insurance policy. There are multiple policies, but none of them are actually valid, right? And now the funeral home doesn't want to touch anything until they know that there's something in place. So a loved one has passed away. What would be my suggested next steps? Now I've called the trust and estates attorney. I've called Miss
Right.
Matthews. What are my next steps? What should I do next?
Well, see, that's we can talk about just general next steps, because no two cases, right, will be the same.
That
Every
makes
case is
sense.
going to be different. So
Okay.
if you called, the next steps are going to, it's going to fall into one of two categories. Is, did the loved one leave a will, or did the loved one not leave a will? If the
Okay.
loved one left the will, then we proceed accordingly with probating that will.
Okay.
Right? That's pretty much the next steps. And then we file an application with we file the application in the county where the decedent either resided, the person who passed away, the resided, or where their last known address.
Okay.
So it's in the county. Let's say, okay, New York City has counties,
Right.
right? So it depends on where. So you can be Manhattan is New York County, Brooklyn is Kings County, Bronx County, Queens County, Staten Island. In Westchester is on Westchester, right?
Right.
Westchester County, or up further up, it could be Rockland County, whatever county, then it gets filed there, right? So, and then again, so it's a form that we have. I walk the person, whoever now the person, it could be the spouse, it could be a child, it could be a friend. If that person now wants to probate their will, let's start with there first. Then now they're going to become, or whoever, usually if there's a will, there's an executor or an executrix that has been listed in the will. And
Okay.
usually that person comes and
Right.
to now want to probate the will. So it's that person that I work with that hires the estate, the trust and estates attorney, and then we work together to get the proper documents filed with the county in order for them to get the, I guess, letters to let the world know that they're now the executor of the decedent, or the person who passed away. Now they're the executor for a male, the executrix for female of now this person's estate.
Okay. Okay.
So that would acknowledge everyone to the world that they are now able to handle this person's estate. Okay, so that's one. It's like I said, it's going to be one of two categories. Either they had a will or they did not.
Okay.
Usually, right, what I find is that people pass away without a will.
Oh, not good.
Right? No, it's not. But that's
Not good.
because we don't know, and so now we're here.
Okay.
Right? So it's like saying we can't cry over spilt milk, so now you're here. So when a
Right.
person passes away without a will, New York now have what we call intestate statutes that now will be applicable. So now everything regarding this person's assets and their estate will now have to fall into these statutes and this category. So pretty much like in this category, anyone can file it. It could be a friend, it could be a spouse, it could be, you know, one of their, a sibling, a child, an aunt, uncle, whoever that person is, right? You just have, you're able to, you can file it, come to your trust and estates attorney. Now you can file, and now you become what they call an administrator of the person's estate, because the person passed away without the will. Now, if the person have living heirs, this soon-to-be administrator needs to notify all the living heirs that that's what they're doing. They're now they're now going to become or going to file a documentation for them to be an administrator of this person's estate. And now the living heirs have to, what we call, consent and waive, and pretty much give them permission, right? To say, it's okay, we're not going to contest it, you go forth, and then you be the administrator and you handle this person's estate. You do what you need to do in that regard, and we're not going to contest. And that I mean, as far as big picture, it was a big picture next steps, because again, no two cases are alike. But again, when you get to that place when a person passes, either one of two categories: did they have a will or they did not?
Okay, awesome. So being that that's the case, so we figured out we now know what estate planning is. We have a concise definition of what it is, right?
Right.
We also understand that we need to go to an estates and trust attorney, right?
Correct.
Somebody that specializes in this stuff, right? We have an idea of what the next steps, at least at a high level, what the next steps are upon somebody's passing. I guess my last question is this: what are the documents that I need to have in place, or that we should have in place, right? We talked about a will. We talked about listing assets, but should we list everything in one space? Should we have all important documents in one place or multiple places? Should we get a safety deposit box to put all of our important documents in? Or should we have a lockbox or a safe at home, or a combination of both? Can you kind of speak to that for us?
Sure. What you can do, so let's say three major documents, right, that one can have. You can have the will, right? Then you have the power of attorney, and then you have the healthcare proxy. So those are the three major documents of estate planning. So the will we list, pretty much you're delegating who you want upon your passing. So that's the will. So it can't, and one thing I think people also, when they think about wills, you can change your will. So just because you did your will today, signed it, we executed it today, and like say, for example, oh, you know what, I wanted to add, I just had a new grandchild, or things change. I may have, I got married, or I got a divorce, or, with this child, this child has a better job now. So now I don't have to provide as much, or certain things that we don't think about when it comes to planning. Some of our children are disabled.
Yeah.
And we don't plan for, like, if my child was, for whatever reason, your child is disabled from birth, you really need, estate planning has to be need to be a priority, because you want to make sure that you have provided for that child throughout their lives, and not really think about, it could have been a medical issue, a medical lawsuit where, you may have money coming in, but still you want to make sure that child is provided for. And then we can I don't want to go into it because it's quite detailed, or maybe complex. You want to set up a supplemental needs trust for that child.
Okay.
Right. And we could actually work that, but that could be a separate document, or you can make provisions even in your will for that child.
Oh, nice. Okay. Awesome.
Right. We can do that. But so again, that's why you would need someone who practices that kind of can walk you through, because if you went to someone who doesn't practice and you have a child with a disability, then that's when, upon your passing, who's going to take care? That's a provision that could have been in the will that was not. And so now you have to go to a trust and estates attorney after all, and now clean up. Right. So it's that's why it's wise. This is a particular area where it's just wisdom to get someone who practices in that area, because of things like that. It's not just a simple will, right? You want to make sure, again, like someone with disability, a child, it could be a spouse. You still want to make sure that they're taken care of when you're passing, right? So you want to have that particular will in place, but then also too, the next document is a power of attorney. Let's say, for example, the power of attorney pretty much allows the person that you designate to be the power of attorney to, you can still act on your behalf. You're not relinquishing everything over once it's executed, but the person can act on your behalf, financial matters, especially if there's a litigation, they can act on your behalf. They can go to the bank on your behalf. You have an elderly person who may not be able to go to the bank, right? That person can act on your behalf. That person now, because of, the state that we're in, the condition, that person should have access to your passwords. They can have access because they have the power of attorney. Where they didn't have it before, now they have it, right? So now they can act on your behalf, and especially the power of attorney is essential. So say, for example, it could be regardless of what age you're in. You may be a 30-year-old and get hit by a bus or a car and you're in a coma. And so it doesn't matter what age you're in versus down to someone who's elderly, and after the power of attorney was executed, they slip into dementia or, anything where they may fall into a coma. So now you have this document. They can't speak for themselves. Like, they can't make the legal financial decisions, right, for themselves. So if there's no power of attorney already in place, now that person, it could be a wife, it could be a loved one, anyone. Now, if they want to do anything financially, really, on the person's behalf, they will now have to go to court and spend thousands of dollars in order for them to become a guardian or have a guardian appointed for that person. And going to court to get that guardianship doesn't take a week or two. Now it can take months unless it's a dire emergency, right? To handle their finances. Yeah. So many people don't know that. And that's, again, when we don't, that's why for me, it's a passion of mine to get this information out, right? I'm not trying to per se clients, but I think it's something that we need to know so that we know how to, again, best plan moving forward. So to have that in place, you can select who you want, that's someone that can handle, that you trust with your money, right? They can trust, with your, again, let's think of power of attorney handling your finances or anything financial or things like that. Like, say, if there's a litigation, they can handle that on your behalf, especially if you're unable to do so. While you're alive, you can do it, no problem. But again, let's think of it as a safety net. Now, that's one document that everyone should have in place, regardless. I think when you're 18, that should be right there.
18, nice. Okay.
Correct. Yeah, you can do it that early. Again, if things happen, he's like, you know what, my relationship with this person changed, or this person's no longer living, you can change it as well. You can change the person that you have deemed to be your power of attorney. Things are changeable. Nothing is set in stone. You just have to just re-execute it. Like, so let's go back to the will. The will is like, things change. You don't have to per se redo the entire will over unless you want to. But you can just, what we call change it, and what we call it a codicil. Right, that's a legal term. Pretty much that means that you can add or change to the will. Again, it's not, you don't have to set in stone, right? That's all that is. And the last document, right, especially now that we're in this pandemic, is that you want to have a healthcare proxy in place. Okay. Right. So that you're giving that person, you let them know your wishes, and pretty much you know that they're going to carry it out.
Okay.
Right.
That's
more
good.
or less. And again, you should have the point person and an alternate, just in case that point person is unable to, maybe they, for whatever reason, excuse me, are unable to fulfill their responsibilities for whatever reason. You have the successor or the alternate that is able to do it. And so those are the three major documents. We have, excuse me, we have another document where if you don't want to be resuscitated. That's another document. But again, the three that I've mentioned are the three major, the basics, right, of a state. Those are the basics that we should all have somewhere in our arsenal, if you will, somewhere tucked away, and letting people that we have designated know where those documents are. Like, you can keep them, and I tell my clients to put them in a fireproof vault, if you will. Things happen. You want to know
Right.
what that is. I wouldn't necessarily say put it in a bank vault, because look where we are. You can't get to the bank.
Correct.
You can't. At least let me step back and qualify that. You can get to the bank, but you may not be able to get to the bank vault.
Correct. That is
right.
correct.
Versus
Depending
something happened.
Right. Depending on which state you're in. That's true. That is very true.
True. Correct. So, but you always have your vote in your home, right? Especially
Right.
if they're saying that you are quarantined, you have that in your home. Or you can say, you know what, healthcare proxy, my healthcare proxy, my power, all my papers are in my house in a vault. You know where that not because some people, I know a lot of people, we don't want to tell people our business, but whoever
Right.
you, that point person, they should know where your documents are. If you
And
listen,
have
give them a
access to it as
combination.
well.
Correct. Give them, I normally give, or I strongly suggest my clients, give a copy of everything to the people, especially like if you have a will, give a copy to the executor.
Makes sense.
You have the original, give them a copy. The power attorney, you keep the original, give them a copy. Healthcare proxy, you keep the original, give them a copy. Because if something happens, it's something, like say healthcare proxy, you get rushed to the hospital, the ER. There's no time to go to a vault to find, where the original is. But if they have a copy,
right, they can use
they have
that
a
copy.
exactly, and the hospital should more or less respect that healthcare proxy, because it was done by a trust in the state's attorney, right? They should be, or really an attorney, but preferably a trust in the states, and they should honor that. They will honor that healthcare proxy, right? So those are things, like I know people, and especially elderly, one thing is that we want to get those documents executed, especially the power of attorney and the healthcare proxy, while the person is their capacity is full, right? While they're at full capacity, right? Because when people start to slip into dementia, it's like executing a power of attorney, a healthcare proxy is like executing a contract. And that's a high standard. That person has to be in there, like have full capacity, full mental capacity in order for it. Like say, for example, people challenge wills all the time, right? Or they want to challenge a healthcare proxy, or they could challenge these documents. But when someone is in their full capacity, have full mental capacity, the challenging is kind of difficult to consider to be valid. Versus a will, that person could just have that one lucid moment, and the will is fine. Right. And they could, have, lack capacity as soon as the will is executed. But as long in that moment, because we have witnesses to attest that person was up, they knew what they were doing, they knew what they were delegating, they knew what they were signing, they told the witnesses that they were signing their will, their last will and testament. That is satisfied. And with people can challenge it, but it's going to be very difficult for them to prevail. Yeah, because we have all these witnesses, and they just had that one good moment, and that's all that's needed for a will, versus the higher standard for a power of attorney in a healthcare practice. Like usually like to tell when people come to me, that's my first thing is, a parent, or I'm not a parent, but often a child comes and say, my parent wants to execute, they want to do a will. My first question is, well, what's the mental state of that parent? Right. Because that's important.
Very important.
Very important. So that's my those three documents are like I said, the basics of estate planning that you should more or less have.
Now those three documents are across the board, no matter what state you're in. You need to have those three in place, at least those three.
Across the board, every state may be different, so I don't want to say, that's a universal United States and across the board, every state is required, because different states, they may have different laws going in. They have different standards for what isn't even needed, or what you need to execute for a will. Right. Some states may, for us, you cannot have a handwritten will. That's not acceptable in New York. However, a handwritten will may be acceptable as like another state. So it really depends. Correct. It depends. Like say in New York, you cannot disinherit your spouse. Right. In another state, you may be able to do that.
Wow, that's interesting. Right.
No. So it depends. It's state by state.
That's interesting. Now, here's I said that question would be my last question, but something you said in your last comment leads me to really my last question. I promise this time, right?
Sure, that's okay. It's all right.
And that's this. Let's paint the scenario. A person already has their will. They already have their healthcare proxy. They already have their power of attorney, right?
Mm-hmm.
How
Right.
often do you suggest those things be reviewed? Because as you said, sometimes relationships change,
Right.
pass away, right? Other things unfold. How often, how long, and I preface that by saying this. I've heard where I won't give names obviously, but I heard where there was a couple that were married. They did their will very early in the marriage, very, very early in the marriage. They had assets. At some point, this couple separated, got divorced. Both parties married someone else, right? One of the spouses passed away later on in life. The only thing that was remaining was the will from the very first marriage, where it awarded everything to the other spouse. That will was never updated. It was never looked upon again. But once the spouse that passed away, once that person passed away, the remaining spouse turned this will up and was awarded everything. Everything that will entitled that person to, they were awarded everything. So my question to you is, how often do you suggest someone that already has these items in place, how often do you suggest they review them to make sure this is still what I'd like to do, or this is still the person or the people that I would like to represent me?
Okay. So let me kind of answer it twofold.
Okay.
So, and see, that's why it goes back to, I guess, your second question about who should you go to prepare these documents,
Right.
right? Because there's careful drafting and certain terminology, because any trust and estates attorney will use certain terminology to make sure, because things happen, right? So it would never be my loving wife, right? You would never use a generic term wife. You would specify, right? Let's say, for example, because you would specify the person's name, right? My wife, or you could say my wife, right? Because if I use my wife, that, then that means my wife, not a former, not my ex-wife, my wife, or whatever. Or so, let me put it this way: there would be terminology that would not reflect an ex-wife.
I see.
Because there may have been terminology where the person's name was there. Because
Right.
the person's name was there, you left it to that person so named in the will. You didn't leave it to your wife.
Got it. Maybe that's what
My
happened.
wife at the time. That had to, I can guarantee you, based on based on the scenario, right? So it's like, again, careful drafting, because a trust and estates attorney would know that things happen in life. So I would never put, there's ways around it, how you draft it and the wording of it. So in the event something happened and they weren't able to change it, then your current, it will not, it would still reflect your current condition.
I see. Fair.
Right.
That makes sense.
So that's the first thing that's why you need to get a trust and estates attorney to kind of prepare those documents. That's one. Two. Now, in regards to that, wow, sorry. So what they need to do is that they should have drafted it properly, right? In order to make sure that does not happen, because now the person who's the current spouse, it's going to be challenging for them to fight it. So how often, I think anytime there's a change, in something major like that, because I can't say, oh, change it every 5 years, 3 years. I mean, it's not like tires, right? You change it every so the pressure's low, right? Then you know that you need to change it. Anytime, I think it's advisable, anytime there's a major change in your life, if you get a divorce, that's the first thing. I need to revisit my will, make sure how is that terminology, because I need to change that. Right. If you get remarried, change it. Certain provisions may be there because you have an anticipation of children coming or great grandchildren. There's terminology that you can use so that, you may or may not need to revisit that. but things major, or my spouse passed away. So I'm not going to leave it to my spouse because they're no longer living. So I may need to revisit my will. So maybe the portion I wanted to leave to my spouse, I may want to now delegate even a greater portion to my children, or now I want to take that portion and may want to give it to charity. So anytime there's a major event that occurs in your life of that magnitude that would change your will in that in that fashion, you need to revisit your will and change it.
Makes sense.
So it's not a time frame of how often, but when something major life situations happen in your life, you want to now revisit that will and say, okay, where are my changes? I need to make a change. And you want to do that kind of as soon as possible, because again, look where we are now, right? Yeah. Right? That precisely, and that's why we're going, and that's why I thank you for having this conversation, because we could start now, because all it's about is preparation right now. We may not be able, unless it's a dire emergency, to execute a will now, but if we can always prepare, so because this restriction, the quarantine is going to be lifted, that we have certain things in place, at least get people to, the information is out. So now we know, like, wow, you know what? Anything can happen. We're talking about a second wave. I want to be prepared in case there's a second wave. I mean, there's a lot of talk going on. It may happen, it may not, but nevertheless, some things may be in place. So I can have certain documents in place, at least have the conversation with a trust and estate's attorney to say, you know, what are my options? What can I do? You know, people think they don't have assets. If you have a pencil, you have an asset, right? I mean, we all have assets. I tell people that because that's be their first line of defense. I don't have anything. We all have something, but it doesn't matter what you think you have. Think about it this way. If you may say, I have nothing.
Right.
I tell people, have something in place. I tell you, if you have a pencil, you have something. You own it, you have it. But also, too, you may, God forbid, get into, you may end up in the hospital, and something happens within the hospital where there's a wrongful death, right? You have nothing in place. No one knows where anything. You have nothing in place to say, oh, I'm going to, and one thing I do want to add about the power of attorney that many people don't know is that when a person passes away, the power of attorney is no longer valid. It's only valid while the person is alive. Correct. Same thing with the healthcare proxy. And that's why it's important to have that will, to have things in place, right? Because without the will, now the court has to, you know, assign this person, or this person goes to the court, if you will, you know, general, and say, I want to be this person administrator. And then it's up to really the administrator to delegate where things go. After they pay, maybe they paid off the person's bills, their creditors, got to handle the funeral arrangements, but then it's really left up to the administrator. And, you know, the administrator may be the person that, you know, the person who passed away, they may have wanted that person to be the administrator, but they also may not want that person to be the administrator. But very possible. But what it does is that the person who passed away doesn't have that choice. The choice is now taken away from them because they did not, while they were living, have that in place. When you say, well, I'm an only child. My mother could say, well, everything goes to you, but it's still good to have, get things in writing. So then it's not a question for anyone.
That's correct. Makes sense. That makes perfect sense. That makes perfect sense. Well, listen, for the sake of your profession and the sake of time, I could ask 1,000 more questions, but for the sake of your time and your professional and in your profession, I think we've given people 45 minutes or something that they would have to sit down with someone and pay several $100s just to get this information. Right. So please tell us, how do we get in contact with you? Now, I will preface it like this: serious inquiries only. Just don't call to say my cat is stuck in a tree. Don't call her for that, right? But how do we get in contact with you?
Sure. So we could phone number, or you can email me, and now since everybody's in quarantine, we could do a Zoom like we're doing now, if we want to meet face to face. But still, to initially get the conversation started, you can reach me via phone at 914-340-4750, 340-4750, or they can email me at natisha@matthewslegalpc.com. I can forward you that information as well as my app, but it's natisha@matthewslegalpc.com. You can start, again, send me a phone call. And I do New York City. I do all of New York. So
Okay.
I do, so it's not just New York City or just Westchester. I do all of New York. I'm licensed in all of New York. So when I have a car, so we can travel. So I do all of New York. So you can call me or you can email me.
Okay, that's great. Listen, again, thank you so much for your time, and I hope that everyone that's viewing this finds value, because this is information that sometimes is very difficult to discuss.
Right.
Sometimes people don't want to discuss it because of where it points, but it is a very necessary conversation. And in this time of quarantine, these necessary conversations have become more prevalent. If
Right.
we're really paying attention, these
Right.
conversations have become more prevalent, if we're really honest with ourselves. So
Right.
for our listening audience, those of you that are going to listen to the replay of this, listen, make sure you get in contact with Miss Matthews. She is an estate and trust attorney. She specializes in that. This is somebody you want to speak to before things spiral out of control, right? With that said, thank you guys so much. Have a wonderful, wonderful day, and we'll
Thank
see
you
you
so much.
soon. Thank
Thank you so much,
you.
Pastor, for having me. Thank you. I appreciate it.
No problem. Thank you.